All right, thank you very much. Can everybody hear me? Can you hear me okay? So I'm not used to this microphone. In court, we don't wear these little microphones, so forgive me if I do this or hit it or something. My name is Chuck Slimp. I serve as Commonwealth's Attorney for Wise County and the City of Norton. Let me see, East Side students here? All right. How about Union students down here in the front? Central students? Well, J.I. Burton students? Hey, very good. Well, welcome to you all. How cool is it that we have 4 different high schools represented here and students from all over the county and the city? Let me begin by saying thank you for joining us. How many of you all are already 18? Okay, a sizable number. So what you are going to see today is 2 actual criminal trials. All right, I serve as Commonwealth's Attorney, so my role is I'm the prosecutor of crime in Wise County in the City of Norton. We prosecute everything from traffic offenses to capital murder. Our office is very busy. Sometimes we have as many as 500 cases on the docket in one day. Last year, roughly in district court, about 11,000 cases prosecuted throughout the year. So that's a whole lot of criminal cases. With that being said, over on this side, you're going to see the Commonwealth's Attorney's table. The Commonwealth will consist of myself as the prosecutor, Stephen Davis as Chief Deputy Commonwealth's Attorney. He'll be with me as well. We have a witness chair right here. This is where the witness will be testifying from. On this side is the defense table. We'll have a defendant, or 2 defendants actually, because we're doing 2 trials, and a defense attorney representing each party. They'll get a chance to question the witnesses as well. Behind them, there'll be the court clerk and the judge and a bailiff. The bailiff is going to come out in just a few moments and call you to order, just like in a normal court. Just like in normal court, when he does so, he's going to ask you to rise. You'll all rise and come to order. Hopefully he won't have to call you down or call you to order. In court, there's a lot of things that happen that are important, a lot of protocols that happen. Number one, a lot of what you guys are wearing today wouldn't be appropriate in court. Shorts, t-shirts are not acceptable in court. And there have been times, you're not going to see that today because everybody's prepared, but there have been times where the judge has had to say, you need to go home, change clothes before you can come back into court. Cell phones are not permitted in court. So if you got your cell phone out today, try to put it away and pay attention to what happens today. It's also going to be interesting because you're going to hear trials on things that might impact you in your life. Speeding, DUI, possession of marijuana, possession of alcohol underage, eluding police, resisting arrest. That's the topics. So as we present these cases today, I want you to pay very close attention, listen to the judge, listen to what happens. I'm going to stop talking, but before I do, I want to recognize 2 very important special people. And I don't think they knew I was going to recognize them. So if I can have Sheriff Ronnie Oakes. Sheriff Oakes, he's still back there? Sheriff Oakes, please welcome Sheriff Oakes. And Norton City Police Chief James Lane. Chief Lane? Chief Lane is out here. So everybody wave at Chief Lane in the back. Very good. All right, well, thank you again. I'm going to hush, and we will come to order in just a second. But thank you again for being here. After the trials are over with, you're going to get a chance to ask questions. So we'll be right back.
The Wise County General District Court is now in session. The Honorable Judge Phillips presiding. Be seated. Come to order.
Good morning. You're in General District Court. This morning, on behalf of the Commonwealth, we're calling 2 cases for trial. And these 2 cases, Madam Clerk, are you ready to call the first case?
Yes.
You may call the first case.
Court calls the case of Commonwealth versus Julie Mason.
Mr. Commonwealth, are you ready today?
Yes, Your Honor.
Do you have any motions or issues before we start?
Not prior to trial. Thank you.
Mr. Fleming, are you ready prepared this morning for the defense?
We are, Your Honor.
And do you have any motions or issues?
We do not, Your Honor.
The first case, Madam Clerk, is we're going to call is the case involving the name of the defendant again, please.
Julie Mason.
Is Ms. Mason with us today, Mr. Fleming?
I'm sorry, Your Honor?
Is she here and prepared, ready to go forward this morning?
Yes, Your Honor, we are.
Mr. Commonwealth, do you have an opening statement this morning?
No, Your Honor, we'll just go straight into the evidence if possible.
Your first witness, please.
We would call Sergeant Ryan Phillips with Wise County Sheriff's Office.
Ryan Phillips, please come up as your first witness. and we'll swear
Ryan
in.
Vanover, excuse me, Judge.
I'm sorry?
Sergeant Ryan Vanover.
Sir, raise your right hand, swear to tell the truth in all matters.
I do, Judge.
Please have a seat, and when you're ready, Mr. Commonwealth, you may proceed.
Thank you, Judge. May it please the court?
You may.
Can you state your name for the court, for the record, please?
Yes, sir. It's Sergeant Ryan Vanover.
Sergeant Vanover, please forgive me for calling you Ryan Phillips a second ago.
That's all right.
That happens. Too many Ryans, right?
Yes.
How are you employed?
With Wise County Sheriff's Office.
And what is your rank?
Sergeant.
How many years have you been with the Sheriff's Department?
In June, it'll be 8 years.
8 years. So what do you do in particular?
I am a canine handler with the Sheriff's Office, and I work patrol.
When you say you're a canine handler, what does that mean?
I have a canine partner that works with me on a daily basis that I work.
So were you working on December 1st of 2017?
Yes, sir.
Were you working alone, or did you have your canine with you that day?
I had my canine with me.
All right.
Mr. Commonwealth, make sure that I understand the case. The defendant is charged with underage possession of alcohol,
Yes, Your Honor.
possession of marijuana. Is that correct?
That's correct.
And resisting arrest.
That's correct, Your Honor. Yep. So on December 1st, 2017, were you, well, before I ask that, do you typically work nights or day shifts, or does it vary?
It does vary, but mainly night shift.
All right, on that night, December 1st, were you working?
Yes.
All right. At about 1:30 a.m., did you have occasion to be called regarding some kind of disturbance at College Life Apartments?
Yes, sir.
All right, can you describe that for the court and how you became aware of something going on?
Yes, sir. On that date, I was dispatched to that location at College Life Apartments for a loud noise disturbance. And whenever I arrived on scene, I could hear noise and screaming coming from the apartment buildings.
Okay. Were you in uniform?
Yes, sir.
On duty?
Yes, sir.
Displaying your badge of authority?
Yes, sir.
Was this in Wise County?
Yes, sir.
Okay. So you heard loud noise and screams coming from the apartment complex?
Judge, I'm going to object. That's leading.
He has an objection. State your objection, please, Mr. Lemmy.
Your Honor, I'm objecting to the Commonwealth leading the witness.
Mr. Commonwealth, he's objected to leading if you'd ask direct questions.
I'll rephrase. Thank you, Judge.
Thank you very much.
So at that time, Sergeant Vanover, did you proceed to try to find out where the noise was coming from?
Yes, sir. As soon as I arrived, I could hear loud screaming, noise coming from an apartment complex. I began walking towards the apartment, and I saw a door standing wide open at apartment 1109.
Okay. So the apartment was open. Were there anybody inside?
Yes, sir. Whenever I approached the apartment complex of 1109, I found the door open. Several people were exiting the apartment.
All right. Did you stop or detain any of those individuals exiting, or could you?
No, sir. They were coming out. As I was walking towards the apartment complex, I could smell strong odor of marijuana coming from the apartment.
Now, based
Judge, I'm
on...
going to object unless he can lay the foundation of how Mr. Vanover knows what marijuana smells like.
I'll lay the foundation, Your Honor.
The objection is that you need to lay a foundation as to why and how he knew the smell of marijuana.
Okay. Sergeant Vanover, you're a canine officer,
Yes,
correct?
sir.
Have you been trained in narcotics detection?
Yes, sir.
Can you describe that training briefly?
In the basic academy that I went through, we did a simulated and an actual burning of marijuana.
Okay.
Smelled the odor of marijuana burnt and unburnt. Also in the training, my previous dog was certified on marijuana, so I trained with it frequently and extensively, and I'm familiar with the odor of marijuana.
And does it have a distinctive smell?
Yes, sir.
And based on your training and expertise, can you describe the effects of marijuana and the dangers of marijuana?
The dangers of it are you never know what it's laced with. It could be laced with fentanyl, which is very deadly. It could be laced with any other type of synthetic drug that's very dangerous as well. So there's all kinds of compounds that people put inside of marijuana that is just not marijuana. So when we come in contact with it and smell of it, we have to be careful ourselves. So it's a very dangerous drug.
So you've been trained in detection of the odor of marijuana.
Yes, sir.
And you just testified that you smelled what you believe to be marijuana coming from the apartment. Is that correct?
Yes, sir.
All right. At that point, you hear screaming, you smell marijuana. What did you do next?
The door was open, people were exiting. I smelled an odor of marijuana coming from the apartment complex. I went inside and I found a Mr. James Smith. I came into contact with him.
And what did Mr. Smith tell you?
He
Judge,
stated,
I'm going to object.
Your Honor, I'm not offering Mr. Smith's testimony or his statements for the truth of the matter asserted, but for why the officer did what he did next.
The objection is a hearsay objection. Obviously, the officer can't relate as what someone else said if they're not here today to testify.
Right.
And so if you could rephrase your question to make sure that it's just leading up to why he was there and not for the truth of the matter.
Did you determine whether Mr. Mason lived there?
Mr. Smith?
Or Mr. Smith, excuse me.
Yes, I did determine that. He did not live there.
All right. Did you determine who did live there?
Yes.
Who?
It was a Miss Julie Mason.
All right. Did you come into contact with Julie Mason that night?
Yes, sir.
And do you recognize anyone in the courtroom today to be Julie Mason?
Yes, sir.
Can you point her out for the court?
It's the female sitting beside Mr. Fleming.
Your Honor, let the record reflect that the witness has identified the defendant, Miss Mason.
May the record reflect that the witness has identified the defendant seated with counsel to her left as the individual that he encountered.
Thank you, Judge. So where was Miss Mason when you found her?
She was lying on the floor.
Lying on the floor?
Yes, sir.
And did there happen to also be other items around her or around the apartment?
Yes, sir. As I mentioned before, I could smell odor of marijuana coming from the apartment. I come in contact with Mr. Smith. I come in contact with Miss Mason. She's lying on the floor. There's beer cans laying everywhere. And at that point, I began to talk to her.
Okay, so did you talk to her?
Yes, sir.
Did she make any statements to you?
She told me to mind my own business and to get out.
Okay. Did she tell you how old she was?
Yes, sir.
How old was she?
She stated that she would turn 21 in a few months.
Did she also show you an identification?
Yes, sir.
And what did the identification report?
That she was 20 years old.
Okay. Now at this time, did you notice anything else notable about Miss Mason?
Yes, there were beer cans laying around the apartment, and also I could smell a strong odor of alcoholic beverage upon her while speaking with her.
Okay. Did you determine whether it was coming from her or the cans around the floor?
It was from her as I was speaking with
Okay.
her.
From her breath?
Judge, I'm going to object to that answer. That's speculation.
What
Honor,
are
he
you
could-
particularly objecting to, counsel? What are
Your
you
Honor, I believe it's speculation. Ask him whose beer cans they were just because they were in close proximity to my client.
Mr. Commonwealth?
Your Honor, the question is not whose beer cans they were, but whether the smell that he observed came from her person or from the cans.
That's pertinent to this case in terms of one of the evidentiary issues is that the officer must be able to ascertain where the alcohol was coming from. Was it coming from a beer can? Was it coming from another person in the room? Or was it coming from the alleged defendant? So we'll allow the question, but he's got to be specific in terms of his testimony.
Yes, sir. So, Your Honor, I'll rephrase to be specific. Sergeant, were you able to determine whether the odor came from her breath, or from the cans?
Yes, sir. As I was speaking with her, it was coming strongly from her person, from her breath, as I was talking with her.
Okay. Did you then arrest Miss Mason?
Yes, sir.
And did you place her in handcuffs?
Yes, sir.
So therefore, putting her in physical restraints?
Yes, sir.
All right. And at that point, did she know she was free to leave?
I told her she was under arrest for possession of underage consumption.
So she was not free to leave?
Right, exactly. She was not free to leave.
What happened when you took her to her vehicle, or to your vehicle?
I'm sorry. As I was walking out, I was trying to place her into a vehicle, and she fled on foot.
How did she flee on foot? Did she take off in the other direction, or what?
Yes, sir. She just bolted, took off running from me.
About how far did she run?
About 25 yards.
All right. And at that point, did you go after her?
Yes, sir.
And did you catch her?
Yes, sir.
And were you able to subdue her?
Yes, sir.
All right. Finally, while putting her back into the vehicle, I assume that's what you did next, right?
Yes, sir.
Did you do any other search or do any pat down or anything of that nature?
Yes, sir. Whenever I was trying to pat her down, that's when she took off.
Okay.
When I did gain control over her again after the small pursuit, I brought her back to the vehicle, searched her again, and found a baggie of green leafy substance in her pocket.
In her pocket?
Yes, sir.
Okay. What was the purpose of your search?
It's for officer safety, and she's in my custody, so I need to make sure everything on her There's no weapons, no guns, no drugs, anything of that sort that can hurt me, hurt herself. As I said, she's in custody, so she is in my control at that point. So she is thoroughly searched.
Officer, have you been trained by the Department of Forensic Science in the collection and testing of marijuana?
I have been trained to field test the substances.
Particularly field testing?
Yes, sir.
Okay. What's involved in a field test for marijuana?
It's a kit that we have in the back of our vehicle that we test certain drugs that we come into contact with before we send them off to the lab if need be.
About how many times have you done one of these field tests?
Numerous.
All right. So you're familiar with how they work and how they show?
Yes, sir.
All right. Did you perform a field test on the brown leafy substance that you obtained from Miss Mason?
It was a green leafy substance, and yes, I did.
Okay.
Tested positive for marijuana.
Positive for marijuana?
Yes, sir.
Officer, last question. Did all of these events happen in Wise County or the city of Norton?
Yes, sir.
All right. Answer any questions that the court or the defense counsel may have for you. Thank
You
you.
may proceed to cross-examine. Mr.
Please, the court. Thank you, Judge. Officer Vanover,
Yes, sir.
once you arrived at apartment 1109, was the screaming still going on?
Yes, as soon as I arrived on scene, there was a loud disturbance, screaming coming from the apartment complex. As I got closer, I did determine it was coming from 1109.
But once you got to 1109 and was standing at the face of the door, was there still screaming going on?
No, people were exiting at that
Okay.
point.
Were any of those people screaming at that time?
I don't recall if they were. They were just, you know, you can imagine a bunch of people coming out of an apartment complex. It's pretty noisy.
Did anyone appear to be in distress or injured?
No, they were just exiting pretty quickly.
Okay. Do you think that was a result of your presence there standing with your badge of authority?
Judge,
More than
objection. That's speculation.
It's speculation.
Yes, Your Honor.
Sustained, motion sustained.
Did any of the people fleeing the room, did they say, oh no, it's the police, let's get out of here?
I don't remember if they did, but I'm sure they did.
Okay, all right. Was the loud music still going on?
Yes.
Did you determine where the loud music was coming from as far as within the apartment?
It was just coming from the apartment complex in that room. I couldn't tell if it was in the living room, the bedroom. I'm not for sure.
The door was open, wasn't it?
Yes, sir.
All right. And my client did not invite you in?
No, sir, she did not.
All right. Was there any threat of imminent danger to my client at that time?
Well, whenever I saw her, I went in to check on her to make sure she was okay due to smelling a strong odor of marijuana coming from the apartment. I went in there to check on her, and she stood up. As I started speaking with her, she appeared under the influence, and then she told me to get out.
But you had already got into the apartment before you noticed her stand up or smelt, or she appeared to be under the influence of alcohol or marijuana?
Yes, whenever I walked in, she was lying on the ground, and whenever I began to speak with her, she stood up.
Okay. So at that point, you've got a young lady in her apartment, you're not invited in, you don't have permission to come in, and she's standing on her own 2 feet.
Right.
So there's no threat of imminent harm.
Well, at that point, it's unclear because she did appear to be under the influence. There's odor of marijuana in that apartment complex.
How did she appear to be under the influence, officer?
She had slurred speech. She could barely speak to me. What she did say was get out. She's very uncooperative whenever I was trying to check on her.
I mean, wasn't it possible she was suffering from diabetes or a seizure at that point?
It could have been, but I did smell an odor of alcoholic beverage upon her person.
Okay. As you got closer?
As I got closer, yes, sir.
Now, did you obtain a search warrant before you crossed the threshold to my client's apartment?
No, sir, I did not.
Okay. And again, how come you felt you were obligated or allowed by law to go there?
We received a call of a disturbance, and I approached the building. The door was open. People were exiting. I could smell an odor of marijuana coming from that apartment complex. She's in there lying on the ground or on the floor. Marijuana is a very dangerous drug, and it can be. Like as I said before, it can be laced with anything. You never know what you're getting whenever you're smoking marijuana. So people have bad intentions when they lace these things. So at that point, I began to talk with her, see if she needed rescue, see what was going on with her.
Did she subsequently get any medical help?
No, sir, she didn't
Okay.
request any.
And once everything was said and over with, did you take her to a hospital or to a clinic, or did you take her into custody?
I took her into custody, yes,
Do you
sir.
know if she got any medical treatment or was checked out by the jail doctors?
I'm not for sure if she did.
Okay. Did you notice any improvement in her condition once you arrived at the jail for her detention?
I don't recall if there was any improvement.
Okay. You had testified earlier that there was a large number of people coming out. Is this 5, 10, 20 people?
There was a lot. I did not sit there and count to see how many, but if there was approximation, probably 10 to 15.
So at least 10 or 15?
Yes, sir.
You didn't detain any of those folks?
No, sir.
Why not?
I was by myself. There was a lot of people there, and I only have a couple of pair of handcuffs.
Did any of those folks seem to be under the influence of alcohol or drugs?
I did not have time to investigate that. They were just exiting, and as I was walking towards the apartment, I see her lying on the floor, so she is my number one concern at that point.
Prior to arriving at a 1109 apartment, did you know who lived in the apartment?
No, sir.
Did you know if there was more than one person living in the apartment?
I did not have any of that knowledge.
Okay, all right. So no one else in the apartment authorized you to cross the threshold and come in and explore?
No, sir.
Okay. Now, once you got outside, let me back up a second, officer. You're certain that the smell of alcohol was coming from her breath? Could it just not have been around on her shirt or like a beer spilled on her?
It was coming from her. She seemed to be under the influence with the slurred speech as I was speaking with her.
Right.
So as I was speaking with her in a close distance there, I could tell it was coming off of her breath.
Did you feel like she was under the influence of alcohol or marijuana?
By the smell, it was alcohol, but I have no way to say that she had been smoking marijuana.
Okay. You couldn't smell that on her, could you?
No, I could just smell it in the apartment.
And at that point, she allowed you to handcuff her?
Yes, she was compliant with that whenever I told her she was under arrest.
Was she cursing you?
No, sir.
And what state of mind did she appear to be in? Was she frightened?
I'm objecting. He can't speculate what state of mind she was in at that point.
Sustained, counsel, you can ask him as to what he saw, what he smelled, what her actions were, but he can't definitively state as to her state of mind. He can't read her mind. But
Did she make any threats or pleas to you? Did she say, please just let me go, this won't happen again?
If she did, I don't remember. If she was begging for me not to arrest her, I don't remember.
So she's handcuffed in the apartment?
Yes, sir.
How far is it out to your squad vehicle?
I would guess approximately 50, 75 yards.
Okay. And during that time, did she make any threats to you?
No, sir.
Did she stumble or fall?
I was holding on to her to
Okay.
make sure she would not stumble or fall.
Okay. And how were you doing? So was she handcuffed in front or back?
The back.
Okay. So were you holding on to her arm
Yes,
from the
sir.
back?
Yes, sir.
All right. So she didn't fall?
No, sir.
All right. Was her speech still slurred at that time?
Yes, sir.
Okay. She didn't run at that time?
No, sir.
Okay. Then once you got to the car, you said you searched her.
Yes, I began to search her, and that's when she took off and fled.
Now, was this for officer safety?
Yes, it is a search incident to arrest. Anytime that we arrest somebody, we are trained to search them.
Okay. So when you felt something in her pocket that felt like marijuana or felt like some leafy substance, you didn't feel like your safety was threatened at that time, did you?
Whenever I began to search her, I actually pull things out of her pockets to make sure there's no guns, knives, bombs, explosive needles, drugs, anything of that sort that could hurt me, hurt her. Anything on her person, she's in my custody at that point. So everything is coming out of her pockets.
And did, where was she at when you did the field test for marijuana?
She was inside of my police vehicle.
Okay. Now, when was it that you say she ran from you?
Whenever I got her to my vehicle, I began to search her, and that's when she took off.
All right. So you recaptured her,
Yes.
and then you conducted the field test.
Yes, I recaptured her, searched her again, finished searching her, found the green leafy substance, then I field
Okay.
tested.
Well, let's back up to this search. Did you turn around and have her face the squad car as you searched her?
Yeah, that's normal practice for us, is to lay them against our car, search the back of their pockets, their waistbands, their ankles, around their boots, inside their boots, up the back, around, to make sure there's no guns, weapons, anything like that.
Okay. Now, was there a female officer accompanying you before you searched my female client?
No, sir, I was by myself.
Okay. And at what point during this search do you say she turned around and ran?
As I was getting ready to put her facing towards my vehicle, I began to pat her down, and that's when she bolted to the left.
Did she appear to be in a state of panic?
She appeared to be in a state of running.
And how fast can my client, who's handcuffed in the back and clearly under the influence of alcohol, maybe marijuana, how fast can she run, officer?
She made it about 25 yards, and then I caught her.
All right, so what, 5, 6 seconds?
Yes, approximately.
Did you have to tackle her, or you just...
I just grabbed hold of her, and then I brought her back to me.
All right. Was she crying at that time, just saying, please, just let me go, or anything like that?
Yes, she was.
Okay. So the tears were coming?
Yes.
All right. After that, was she very compliant with you?
Yes, sir. At that point, she did become very cooperative with me. She didn't run again. I told her not to, that, she would be charged with multiple offenses at that point. So.
No further issues all the way back to the detention center?
No, sir.
All right. Your Honor, that's all I have. Thank you.
Thank you. Mr. Commonwealth, you need to redirect.
Just one brief, if I may.
You may.
So, officer, you were questioned about whether it appeared at the time you entered the apartment that someone might be in danger.
Right.
Right? And that was based on the smell of marijuana?
Yes, sir.
So you also testified about the dangers of marijuana, but are there dangers of mixing marijuana and other drugs and alcohol?
Yes, sir.
Okay. Thank you, Judge. That's all.
Any recross, Mr. Fleming?
No, Your Honor.
Thank you. You may step down, Mr. Vanover. Any other witnesses,
Thank you,
Mr.
Judge.
Commonwealth?
No, Your Honor, we rest.
Commonwealth rest. Mr. Fleming, would you seek to call any witnesses?
No, Your Honor, my client wishes to exercise her Fifth Amendment right to not incriminate herself.
So no, do you have any witnesses other than the defendant?
I do not, Your Honor.
So the defense rests.
Yes, Your Honor, we do.
Any motions from the Commonwealth or at this stage from Mr. Fleming?
No, sir.
Argument, please, Mr. Commonwealth.
Thank you, Judge. Your Honor, this is a simple case. First and foremost, we ask the court convict Ms. Mason on all 3 counts. First, regarding the marijuana possession, after she was placed under arrest, incident to arrest, a normal search occurred. The officer, patting her down for officer safety, found a bag of green leafy substance. He testified as to his extensive experience, training identifying the odor of marijuana, but also training exercising the DCGS field test kit. And that test came back that it was positive for marijuana, that marijuana was in her possession and control at the time of this incident. Second, regarding the underage possession of alcohol, she testified, or the officer testified that she told him she was 20, just a few months before she turned 21. He checked her ID. That was consistent with her identification. Not only was there a number of beer cans around her in the apartment, but there also was a strong smell of alcohol from her person, from her breath. She appeared to be intoxicated, being unsteady on her feet, having slurred speech, glassy eyes. He testified as to all the indicators of one being intoxicated. And thus, by consuming the alcohol to make her intoxicated, just the consumption alone is enough to be in possession of alcohol by someone underage. So we ask that you convict on that count as well. And then finally, resisting arrest and fleeing from the officer. Under our code, fleeing from an officer after he has placed you under arrest, after you are not free to leave, after he has placed someone with physical restraints, but the act of running from the officer or trying to escape from the officer, it constitutes resisting arrest under the code in the cases, and we've proven each of these cases beyond a reasonable doubt. I would finally say that we ask the court to not only convict, but send a strong signal to Ms. Mason that this type of behavior is unacceptable in our county, in our community. Not only is it highly offensive conduct, but also very dangerous conduct. When the officer found her, she was lying on the ground. She was intoxicated. There's a whole lot of people in the room screaming, lots of loud music. The officer thankfully intervened before she could consume more drugs or alcohol and cause further harm to her safety. Not just that, but even after that, she continued to be uncooperative by running from the officer. So we would ask that the court fashion an appropriate sentence, convict, and fashion an appropriate sentence to send a signal that this is unacceptable. Thank you, Your Honor.
Thank you. Mr. Fleming.
Yes, Your Honor. Judge, in considering the case and make a determination upon guilt and punishment, would ask the court to consider that no evidence has been submitted to this court that my client has any prior bad acts, no previous charges, and certainly no convictions. It appears this would be a first-time offense for my client. A young lady who got caught up in the college life and unfortunately made bad decisions, and unfortunately, unlike the other 10 or 15 people who ran, the officer chose not to detain, she's suffering the burden from that, because that's where she lived. It seems very unfair that she should be the one singled out just because that's where she lives. Judge, having said that, the defense would concede that they've proven their case as far as possession of alcohol. Judge, I would ask the court to place my client in the first offender program. Well, this may sound like it's not much, and my client will lose her license for a period of 6 months. She'll have to get rides from other people, or she'll have to walk. She'll also be on probation for 12 months, and she'll be subject to alcohol abuse assessment as well as counseling, and she'll have to have random drug screens. She'll also be subject to search and seizure at any time. I think that would be a sufficient punishment for a 20-year-old experimenting with beer. Your Honor, we do not concede that the Commonwealth has proved their case as far as the marijuana. At first blush, it seems like finding something in her pocket means it's hers. However, the Commonwealth has the burden to establish dominion and control. The officer didn't testify that she knew it was in there prior. These may have been a roommate's pants. She may have picked something up in her floor when other guests were in there and thought it was garbage and put it in. Judge, as far as resisting arrest, the officer stated that she made it 25 yards, and you can see my client. She's not a very tall person. The officer is good, officer in good shape, adept at chasing someone down. But more importantly, my client was in handcuffs, and she was under the influence of alcohol. So 25 yards is about as far as she made it. Judge, I would submit to the court de minimis non currit lex, which is Latin for the law does not sweat trifles. This is a very minimum thing. This young lady who got scared, and this large officer carrying a gun and handcuffs was about to take her to jail where she's never been. We ask you to dismiss the resisting arrest, Your Honor.
Thank you.
May I respond, Your Honor? Your Honor, first, Mr. Fleming is correct that you must demonstrate dominion and control of the marijuana, but I think it's preposterous to say that it was maybe her roommate's pants. She was wearing these pants. That marijuana was in her exclusive possession and control in her pocket while she was under the influence on that night. So I think that argument fails flat. Then second, I think I want to also address the resisting arrest charge. It doesn't matter how far she ran. If she ran while she was not under authority to leave, after the officer had communicated that she was under arrest, that still is a violation of the law and should result in a conviction. And then finally, regarding the first offender status, I think this court should make abundantly clear that bad decisions, even the first bad decision, has consequences and should be punished. Thank you, Judge.
Thank you, gentlemen. The court has listened to all the facts and evidence in this case, and I'm going to take each charge separately and announce to the defendant what the court's decision is. Now, let's take the underage possession of alcohol. Based on the totality of all the evidence, in this particular case, the court is going to find the defendant guilty of underage possession of alcohol. You can possess alcohol by having physically in your hand, and it's illegal in Virginia for someone under the age of 21 to have that alcohol in their possession. It is also equally illegal in Virginia by statute to have alcohol in your system. It's possession of alcohol in your system. And so in this particular case, the officer testified that he smelled a strong odor of alcohol coming from her. They was having a party, and obviously alcoholic beverages were being consumed there, and he smelled it coming from her breath. And based upon his evidence that she had slurred speech and she was not really coordinated in terms of her actions, and she was sort of disorientated, and those are some of the prime signs of being under the influence of alcohol. In this state, an individual, ma'am, cannot possess alcohol if you're under the age of 21. It's illegal to have the alcohol in your system. The court finds you guilty, and because it is your first offense, we're going to defer disposition on this case. Mr. Fleming outlined all of the conditions that the court is going to place you on under the first offense It has to be only a first offense, possession of alcohol in this case. Ma'am, what we're going to do is take this case under advisement for 12 months. I am going to, for the record, find you guilty, but not enter a guilty plea. It's called a deferred disposition in this matter, deferred sentencing, a deferred disposition. And so what we're going to do is require you to do 50 hours of community service in this case. We're going to require you to have a probation officer for 12 months. And that probation officer has the right to test you randomly for consumption of drugs or alcohol. We'll ask the probation officer to place you in alcohol treatment and drug treatment and assessment to assist you with any issues that you may have. In addition, the court is going to fine you $250 and they're going to take your driver's license for 6 months in this case. I could take it for 12 months, but in this particular case, I'm going to take your driver's license for 6 months. You may see if you qualify for a restricted license, and I will consider that. So deferred disposition on count 1. Count 2 is simple possession of marijuana. The court finds that the marijuana was in your possession, it was in your control, and one will find you guilty. Quite frankly, the court has heard that defense before. It's not my pants defense. And so we've heard that defense before in this case, and so it's not uncommon for people try to deny the possession of marijuana or drugs saying, they're not my pants. I don't know where it came from. I must have picked up the wrong pants, put on the wrong pants. And I think sometimes people say things, I assume at the time that they are caught and then subsequently arrested to try to get out of charges, but in this case, court finds you guilty. Simple possession. I want to suspend your driver's license again for an additional 6 months, which I can, by statute, so you're going to have a total of 1 year loss of your license. And the court is going to fine you $250 in this case, and the court is going to place you on 12 months of unsupervised probation for the marijuana charge. For resisting arrest, ma'am, the court finds from the totality of the evidence that you broke from the officer, you ran from the officer, and you made it more difficult for the officer to make your arrest in this particular situation by separating yourself from the officer. The court finds you guilty of that, and I'm going to give you 10 days in jail. And quite frankly, the 3 matters, and you made things worse by simply resisting arrest, by fleeing from the officer, and I'm going to give you 10 days in jail, but I'll give you credit for any time that you served in jail. Ma'am, I hope that you have an opportunity to reflect on what charges you have, what the disposition of the court's finding of guilt today, and I sincerely hope that you're able to correct any issues that you may have regarding alcohol and marijuana. This is your first offense, and the court does take into consideration that it is your first offense. Ma'am, but I see you again in this court, and you have underage possession of marijuana resisting arrest. The court will listen patiently and will try to assess the evidence. If the evidence shows that you have similar violations, I will give you additional jail time without any question, ma'am. So, officer, if you'll take her into custody. Yes, sir.
If I may, Herb.
You may.
Your Honor, my client is a college student. Exams are coming soon. Can she do weekends for jail?
Mr. Commonwealth, any objection?
No objection to that.
Mr. Commonwealth, since she is a college student, the court does have the discretion to allow her to have weekend jail at the jail. And we'll put in our order today, she is to report Friday night at 7. And she is to be there at 7, prior to 7. If she's not there by 7, then she'll get additional charges of failure to be where she's supposed to be, of breaking her probation, breaking the terms and conditions of order, and I'll give her additional time. So, ma'am, be there at 7
Thank
o'clock.
you, Judge.
And you'll have 5 subsequent weekends to serve.
Your Honor, we would request that she would be on supervised probation until she goes to jail Friday.
She's currently on supervised probation, and she'll be on supervised probation for 1 year. You understand, ma'am, you'll break your probation if you're not there on time and you report every weekend. Now, I don't want to hear any excuses. You report every weekend until your time is served.
Would you go with the officer? He'll take you to the clerk's office.
He'll take you down to the clerk's office, ma'am, and sign you up to pay your fines and your costs.
Thank you, Your Honor.
Thank you. I will conclude this case. Gentlemen, do you have another case for the court to call? Madam Clerk.
Yes, Your Honor.
We do, Your Honor.
Call the next case, Madam Clerk.
The court calls the case of Commonwealth versus John Lawson.
Mr. Lawson, could you come up, please? Speeding, which is a traffic and misdemeanor eluding, it looks like in this case. And for the parties, DUI could be either alcohol or drugs or combination. The eluding is once an officer has put on the lights and siren and the person has not stopped for the officer, then they can be charged with a misdemeanor and get up to 12 months in jail. Gentlemen, are you ready? Mr. Commonwealth?
We are, Your Honor.
Any motions or issues?
Not from the Commonwealth, Judge.
Your Honor, we would remind the court that there's also a speeding allegation
yes,
as
Judge.
well.
We announced there is a speeding allegation as
Yes,
well,
Judge.
which is by summons. Mr. Defense Counsel, do you have any issues or motions?
No, Your Honor.
Are you prepared and ready to go forward?
Yes, Your Honor.
All right. You may call your first witness, Mr. Commonwealth.
Your Honor, may it please the court, the Commonwealth will call Sergeant Jason McConnell with Norton Police Department.
Sergeant McConnell, please come up. Please raise your right hand and swear to tell the truth in all matters, sir. You may have a seat. You may proceed, Mr. Commonwealth.
Could you please introduce yourself to the court?
Yes, I'm Sergeant Jason McConnell,
And where are you employed?
City of Norton Police Department,
How long have you been employed there?
9 years.
And what are your duties there?
Maintain order, patrol the city, look for crime, any laws that are being broke.
Sergeant, were you on duty on or about November 21st of 2017?
Yes, I was.
Can you tell the court about what happened in this case?
All right. On November 21st, 2017, while traveling on Park Avenue, I noticed a vehicle coming in the opposite direction of me at a high rate of speed. My radar unit advised that vehicle was traveling 43 miles per hour in the 25 mile per hour zone.
Now, what is the speed limit in that particular area?
25.
Now, Park Avenue, that's kind of like Main Street through Norton.
That's correct, yes.
And what kind of vehicle did you observe?
It was a green Toyota sedan.
And based on your reading on your radar machine, what happened next?
At that time, I did a U-turn to get behind the vehicle. I activated my lights and sirens, and the vehicle disregarded, continued to travel for approximately half a mile.
Let me stop you there. What kind of vehicle were you operating that day?
A marked police car.
And what kind of lights did that vehicle have?
It has blue flashing lights, and it has a loud siren that goes with it.
And were you in your uniform that day? What were you wearing?
Yes, I was. Same uniform I'm in now.
Similar to what you're wearing today?
That's correct.
Did you have the same badge of authority on that day?
Yes.
So once you activated your siren and your lights, what happened next?
The vehicle failed to stop. It continued to travel at about the same rate of speed for approximately about a half a mile before it came to stop.
And what happened next?
At that time, we pulled into the driveway of 133 East Street in Norton. I pulled behind the vehicle and made contact with the driver.
I know you've touched on this, but that location where you stopped, is that located in the city of Norton, Virginia?
Yes, that is.
Which, of course, is in Wise County, correct?
That's correct.
All right, and keep going. What happened next?
All right, I identified the driver by his Virginia OL to be a Mr. John Lawson.
Now, let me ask you, officer, do you see the person that you identified then as Mr. Lawson? Do you see him in the courtroom today?
Yes, I do.
Could you point him out for the court?
That's him right there.
All right, ask the record to reflect he has identified the gentleman sitting beside of Mr. Carrico as the driver of that vehicle.
Please let the record reflect that the officer has identified the defendant seated with counsel.
So you approach the car, make contact with Mr. Lawson. What happens next?
While he's rolling his window down to give me his Virginia ID, I smelled a strong odor of alcoholic beverage coming from the vehicle and off of his persons.
Based on that, what did you do next?
I asked him to step out of the vehicle.
Okay, and what happened next?
At that time, he stepped out. I noticed that his eyes were bloodshot and glassy, and his speech was severely slurred.
And based on your training and experience, what did that indicate to you?
That he was possibly impaired.
Okay, so based on that, what did you do next?
At that time, I performed some field sobriety tests on him, and the first one I performed was the horizontal gaze nystagmus test.
Now, what was the purpose for performing these tests?
These are standardized field sobriety tests that will evaluate how intoxicated or if a person is intoxicated. That way I can make a good determination.
And was he compliant with you? Did he do everything you asked at that point?
He was loudly talking, but he was compliant.
And so what was the first test that you gave?
The horizontal gaze nystagmus test.
Now, what is that test? Can you explain what that test is?
Yes, I can. Horizontal gaze is an involuntary movement of your eyes that if somebody's been drinking or under the influence of some type of medication, your pupil will involuntarily move. It will not happen any other time. And so I perform that test.
How do you give that test? What do you do?
I ask them to stand still with their hands down by their side, feet together, and I tell them to follow my finger or my pen with their eyes only, not moving their head.
You stand in front of them?
That is correct, yes.
And at that point in time, had you had any training on that particular test?
Yes, I have.
What type of training had you undergone?
We had standardized field sobriety training when I was in the police academy.
All right. And can you explain to the court what happened when you gave that test?
When I gave that test, the first thing I noticed was that he had nystagmus at 45 degrees, and he also had nystagmus at maximum deviation.
What does that mean exactly?
What that means is when he's following my finger, once we get to about 45 degrees in his eye, the eye will involuntarily jerk.
And based on your training and experience at that point in time, what did that possibly indicate?
That he was under the influence of something.
So after you performed that test, what did you do next?
The next test I asked him to perform was the one-leg stand test.
And what is that test?
This test is a test where I have them stand with their hands by their side and tell them whichever foot they choose to put it in front of them 6 inches and to count out loud and do so until I tell them to stop.
And what are you looking for when you give that test?
Balance. See how well they're able to balance themselves.
And how did Mr. Lawson perform when you gave that test?
He failed.
Can you
Objection
explain?
to the conclusion, Judge.
Judge, I'll rephrase the question.
Obviously, he can't, these tests that you're talking about, Mr. Commonwealth, there's no pass, fail. There is clues that he looks for to determine potentially the possibility of alcohol or drugs.
Yes,
And
Your
so
Honor.
sustained, you may rephrase your question.
Understand, Judge. So when he began to perform this test, what did you observe him do?
He used his right leg, put his right leg up 6 inches from the ground. Upon doing so, he's very unsteady on his feet, and he had to keep putting his foot down to keep his balance.
Did you observe anything else?
I actually stopped the test for his own safety. I was afraid he was
Why did you stop the test at that point?
I felt it was going to be unsafe for him to continue. If he had continued, he might have fallen and hurt himself.
So what did you do next?
All right, the last test I performed was the alphabet test.
And what is that?
That is a test where I first ask them if they know their alphabet. If they do, I'll ask them to start a letter and end at a letter. In this case, I asked them to start at E and then end at K.
And what are you looking for when you give that test?
Let's see if he's able to follow my directions.
And what occurred when he began that test?
He did it with no problems. He successfully completed that test.
Okay, so based upon everything that you had observed at this point, what did you do next?
Based on the way he did the first two tests, the horizontal gaze nystagmus and the one-leg stand, and the fact that I did smell a strong odor of an alcoholic beverage coming from his persons, I placed him under arrest for DUI.
And officer, if I may back up just a little bit, was anyone else in the car with him?
No.
And he was in the driver's seat when you approached the vehicle?
Yes, that's correct.
Once you placed him under arrest, what did you do next?
At that time, I transported him to the Norton Police Department.
Had he made any statements to you at that point in time?
He advised that he had to go to the bathroom, and that's why he was trying to get home.
Once you arrived at the police department, what occurred next?
While at the police department, I observed him for 20 minutes. He agreed to take a breath test on our intoxilizer instrument.
He said you observed him for 20 minutes?
That's correct.
What is the reason for that?
The reason for that is to make sure that he doesn't burp, belch, regurgitate, anything like that. That way we can get an accurate reading of exactly how much alcohol is in his system.
So what did you use to detect if there was any alcohol in his system at that point?
It's an instrument. It's called the intoxilizer, and
That instrument is at the police department?
that's correct.
And what is that instrument? How does it work exactly? What does it do?
What it does is, once the subject blows into a tube, it will read his breath and calculate it with a formulation that they have in there, and it will come up with a reading of how much alcohol is in his system.
To operate that machine, do you have to have any type of special certification or training or anything?
You do, yes.
What do you have to undergo to operate that machine?
You have to go and be certified by the Department of Forensic Science in Richmond. It's a 3-day course.
Back in November of 2017, had you undergone that course?
I had, yes.
Had you been certified to operate the machine?
Yes.
And you stated during the 20-minute period, did you see if he burped, belched, anything? Did he have anything in his mouth?
There was nothing in his mouth. I checked his mouth. He did not burp, belch, or regurgitate at all.
You said he agreed to give a breath sample into this machine.
That's correct.
What occurred when he gave the breath sample?
Once the machine finished with his breath samples, it indicated that his blood alcohol level was a 0.10.
Your Honor, may I approach the witness?
You may.
Judge, I have shown this to defense counsel. Officer McConnell, do you recognize this document?
Yeah, yes, I do.
Tell the court what that document is.
This is the certificate of
Any
analysis.
objection, to the document, Mr. Commonwealth?
No objection, Judge. Subject
No objection?
to cross.
Subject to cross.
Can you tell the court what that document is?
This is the certificate of analysis that was printed out by the intoxilizer instrument.
What does it indicate that his blood alcohol level was?
0.10.
Your Honor, the Commonwealth would ask to admit this as Commonwealth's Exhibit Number 1.
Defense counsel, any objection to the breathalyzer printout coming in as an exhibit?
No objection at this time.
Be admitted without objection, subject to cross-examination. Mr. Commonwealth may proceed.
Your Honor, I believe the Commonwealth would rest.
Okay. Commonwealth rest. Questions from the defense?
Yes, Your Honor, thank you.
Come up.
So, officer, where did you actually arrest my client?
It would be in the driveway of 133.
So you arrested him on private property?
At that time, yes.
He wasn't on a public street or anything like that when you arrested him?
Not at that time.
And so you said that he was going at a high rate of speed. What did you clock him at some speed above 25?
Yes, my radar had him at 40.
Were there any other cars coming by at the time that you were tracking him?
He was the only one in my radar's path.
The only one. So that's not my question. So were there any other cars coming towards you besides, or in
Not
the
at that
opposite
time.
lane? Okay. So you said that you followed him for half a mile?
That's correct.
All right. And then you've charged him with misdemeanor eluding?
Yes.
So, I mean, you've been doing this for 9 years, so let's just say, so in your 9 years of training, so if somebody goes half a mile, does that automatically constitute eluding?
It could.
It could.
It could.
So sometimes it couldn't. Are you saying that?
Every time I've done it, I've charged them, yes.
Every time?
Yes.
Okay, that's not what you just said, though. You said sometimes it could.
It does, yes.
All right. So, I mean, did they teach you that in the police academy? It was like, what, 100 feet, past 100 feet, that's eluding then. That's when I've decided that I'm going to...
Judge, I'm going to object to this. Judge, I'm going to object to this line of questioning. It's requesting a legal conclusion, which is for the court's purview at this stage. He can ask for his policy on when he might charge that offense, but as far as whether it constitutes an eluding or not, that's for the court.
Counsel, any conclusions that you may make regarding the guilt or innocence of a party remains with the court, and so you may ask any questions about the eluding in terms of how it happened, what he observed, what conditions that were present, and what basis did he have for probable cause and arrested him for the eluding. You may ask any of those questions.
Thank you, Judge. So, okay, so you get to the point where he gets out of the vehicle. You said he's cooperative with you.
That's correct.
You said that he had slurred his speech, though.
Yes, speech was
So was he being loquacious that day and just having a big conversation with you or something like that?
No, he was trying to advise me why he was getting to his house. And
What did he tell you?
That he had to go to the bathroom.
All right. Does that ever occur to you when you had to pull somebody over because they were speeding because they had to go to the bathroom?
It has, yes.
Did you always charge them with something after that?
Judge, objection to that question. I don't think that's appropriate.
It's not relevant, sustained. You may proceed.
Okay, thank you, Judge. So you started performing the field sobriety test.
Yes,
All right. You said that you did the one-legged stand test.
that's correct.
So you would agree that not everybody, even if they're sober and haven't had anything, any drugs or alcohol, could have a problem standing on one leg.
If there's no injuries to their back or legs, they should be able to do it just fine.
Well, that's not something that everybody does every day, is it? They don't wake up in the morning and say, I'll just decide I'll stand here and see for 20 seconds and see if I can stand on one leg.
That's correct.
All right. So then you said that he passed the alphabet test.
That's correct.
So what exactly did you ask him to do on the alphabet test?
I asked him to start at the letter E and end at the letter K.
That's not something we learn in grade school either. We don't learn from E to K, do we?
No,
I mean, we learn it from the beginning to the end.
that's correct.
So, but he passed that one fine.
He did, yes.
So are you taught in the police academy, hey, if he passes, 1 out of 3, then I'm not going to charge him with a DUI?
Based on my training experience with the other two tests, felt that arrest for DUI was warranted.
That's all the questions I have, Judge.
Any redirect to Mr. Commonwealth?
Or just one or two questions.
You may.
Officer, I know you hit on it, but what did the speed of the vehicle, what did your radar indicate when you first came into contact with the vehicle?
My radar advised that he was traveling at 43 miles per hour.
And as you said, that's a 25-mile-per-hour zone, correct?
That's correct, yes.
That's all, Judge.
Any questions?
No further questions.
Officer, did he speed up after you got behind him?
He maintained the same speed the whole time. Never slowed down, never sped up at all.
And the only reason he gave you why he was trying to get somewhere is because he needed to use the restroom?
That's correct, Your Honor.
And so how far did he travel before he stopped?
Approximately about a half a mile.
Thank you. Any questions, Mr. Commonwealth, engendered by the court's questioning?
No, Your Honor.
Mr. Defense Counsel?
No, Your Honor.
No questions from Defense Counsel. And Mr. Commonwealth, any other witnesses, or do you rest?
No, Your Honor, the Commonwealth would rest.
Commonwealth rest. You may step down, officer. And Defense Counsel, have any witnesses that you wish to call or motions?
Judge, we would call Mr. Lawson.
You may call him. Sir, come up and we'll swear you in, swear to tell the truth about all matters. I do. Thank you, sir. Have a seat.
So you're John Lawson?
I
And
am
where do you live, Mr. Lawson?
in Norton.
Okay. Do you remember the nights that the night of the event that the officers testified to?
I do.
Tell the court exactly what happened that night.
I'd been over to Buddy's house and we'd had a beer or two, no more than two, and his wife was in the shower and I had to go to the bathroom, so I come on home. I was in a hurry. I was under pressure.
And did you tell the officer that when he pulled you over?
I did. He didn't believe me.
What did he say to you?
He made me do all them stupid human tricks standing on one foot. I couldn't have done that if I hadn't been drunk.
Do you usually stand on one foot during the day, every day, to practice that?
No.
Everyone needs to come to order.
So, and this was actually where he arrested you, was actually in your driveway.
I pulled in my driveway.
All right. Did you have any intent to run away from the officer?
No, I didn't even know he was back there.
He said that he had his blue lights flashing and his siren going. Did you hear or see any of that?
I saw the blue lights. I thought he was one of them people with them blue headlights in their truck.
Did you tell the officer that when he pulled you over?
I did. He didn't believe me.
So how many drinks did you have that night?
2 beers.
And did you tell the officer that as well?
Mm-hmm.
That's all the questions I have, Judge.
Cross, please, Mr. Commonwealth.
May it please the court.
You may.
Why did you run from the officer?
Objection to the way he phrased the question, Judge. He's saying it's a conclusion, drawing a conclusion. He run from the officer.
He can, Commonwealth, it's your witness. He can lead the witness at this point. I'm going to allow the question.
Thank you. Why'd you run from the officer?
I wasn't running from the officer. I was running to the bathroom.
But you saw the officer make a U-turn, right?
I wasn't paying attention to him. I was focused on getting to the house.
You saw the police car. It was a marked car, right?
I saw that, but
You saw the blue lights.
I thought it was one of them blue lights in them pickup trucks.
You heard the sirens.
I had my music on.
You went for a half a mile after he initiated the stop, right? Half a mile.
That's what he said.
And you were speeding during that half mile, right?
I wasn't thinking about my speed. I was just going.
Because you didn't even slow down. You were just going
No, just going.
through a residential zone.
They fly through there all the time.
Now, Mr. Lawson, you don't have any vision issues.
No.
You don't have any hearing issues.
Huh?
Hearing issues?
No.
You don't have any back issues or any issues standing, do you? You walked just fine this morning.
I'm fine.
All right. That day, the officer, you heard his testimony. Your eyes were bloodshot, weren't they?
He said they was. I wasn't looking in the mirror.
And your speech was slurred, wasn't it?
It may have been.
You admitted drinking.
2 beers.
2 beers.
Just 2.
They were tall ones, weren't they? They had to be.
You didn't ask how big, but they were kind of tall.
And then, after consuming alcohol, they weren't non-alcoholic, right? They were alcoholic beers.
They were alcoholic.
Then, after consuming alcohol, you got in a motor vehicle, right?
Mm-hmm.
You turned on that vehicle and you drove down the road.
Yes.
You were unsteady on your feet when he got you out, right?
That's what he said.
Well, I mean, you tell us you had to put your foot down several times, right? You testified earlier you don't have any issues walking or standing or anything.
I stumble every once in a while, but that's because I'm old.
Well, you stumbled that day because you were drunk, right?
I don't know.
Well, you heard the officer. You were above the legal limit, right? 0.08. You were above 0.08, right?
That's what he said. I didn't feel like I was.
You didn't feel like you were drunk?
No. I drive like that all the time.
You ever been convicted of a DUI before?
No.
You ever been convicted of a crime of moral turpitude or a felony?
I don't think so.
A crime of moral turpitude would be a crime of stealing, cheating, lying, anything like that?
No.
No? Or a felony?
No.
All right. You sure about that? You're unsure of a lot of things today, but you're sure of that.
I'm sure of that.
All right. Thank you, Your Honor.
Any redirect, Mr.
No further questions, Your Honor.
Carrico? Thank you. May he step down?
Yes, Your
You
Honor.
may step down, sir. Any other witnesses?
Defense rest, Your Honor.
Defense rest. Mr. Commonwealth and defense counsel, do you have any argument or motions for the court?
Yes, Your Honor.
Just argument, Your Honor.
Please, you may proceed, Mr. Commonwealth.
Your Honor, this is a classic DUI case. The defendant admitted to drinking beers, 2 beers. He didn't say how tall they were. He's clearly over the legal limit based upon the test, 0.10. Legal limit in Virginia, 0.08. But I would remind the court that even if you're not over the legal limit, that simply operating a motor vehicle, even on private property, here he was on the road, but even on private property, operating the motor vehicle is not just driving down the road. I mean, it could be sitting in the car with the ignition on. But here, he took it a step further. He drove. He admitted to drinking. He admitted to driving after he had been drinking. He was over the legal limit. He was clearly intoxicated based upon the bloodshot eyes, the slurred speech, the inability to stand on one leg. Not just that, but he failed this particular test and smelled of alcohol. And moreover, he testified today, he drove after consuming alcohol. He couldn't determine how big these particularly 2 beers are. We've heard that 2-beer defense before. It doesn't matter whether he consumed a half an ounce. if he consumed a little bit of alcohol that messed with his motor functions, that's sufficient. So we will ask the court to convict him of a DUI. We would ask the court to convict him of speeding. And moreover, we would ask the court to convict him of misdemeanor eluding. Now, the crime of eluding, Your Honor, is driving or running from the officer with your vehicle after receiving the audible or visible signals to stop. I think he was not credible with the court today. He was very evasive with the court. The officer told and testified to the fact that he had a very loud siren. He was in a marked police car, and he had the blue lights on. Mr. Lawson today testifies he didn't know if it was a big truck with lights behind him or not. I think he's lying to the court. I think very clearly he knew what he was doing. He was trying to get away from the officer because he knew he'd be guilty of a DUI. He knew he'd been drinking. He knew he was driving, and he shouldn't be. So he was trying his best to get away from that officer. Now, he didn't endanger the public, which would be the standard for felony elude, but he did elude from the officer. And therefore, we ask the court to find him guilty. And not just that, but to issue a significant punishment for this gentleman, because he deserves jail time, a significant amount of jail time, for what he could have done. He could have killed somebody out there on the road, driving intoxicated, driving at a high rate of speed through a residential zone. There are kids that are out there every day walking around playing on Park Avenue. He could have killed somebody that day. Thank God he didn't. He needs to have a lesson that this is unacceptable. Thank you, Your Honor.
Thank you, Mr. Commonwealth. Defense counsel, Mr. Carrico.
May it please the court. Judge, the Commonwealth just said this is a classic DUI case. Well, nothing can be further from the truth. First of all, usually, as the court knows, you hear most DUI cases where you hear that, oh, the person crossed the center line, or the guy was swerving in his lane, or whatever, or there had been an accident or something like that. That's when you have a typical classic DUI case. That's not what we have here. What we have here today is a man who's testified under oath, and you're the judge of credibility, that he had to use the bathroom, and he was emphatic about it. The Commonwealth asked him, well, you know, you didn't see the lights or you didn't hear the siren. He gave very plausible explanations for that. He said, my mind was not on anything besides going to the house and using the bathroom. So this is not a classic DUI case. Judge, I could argue the defense of necessity, as the court well knows, that if something is necessary to somebody, then they sometimes can be excused from following the law in certain cases. But in this case, let's look at the misdemeanor eluding. He said that he was trying to get home to use the restroom. So in order for him to be eluding, to be running away from the police officer, then he has to have the intent to do that. He has to that's his intent, is to get away from the officer, to escape. Why would he go to his house if he's trying to get away from the officer? That makes no sense. That defies common sense. So we would say at the very least that charge should be dismissed and my client be found not guilty of that. As to the rest, Judge, you are the judge of credibility, and we would ask that you dismiss the misdemeanor eluding charge. He's never had a DUI before. He did pass one of the sobriety tests as testified to, and if the court does find him guilty of the DUI, we would ask that the court give him suspended jail time. Thank you.
Thank you.
May I respond to that, Judge? The defense of necessity has nothing to do with this particular case. It does not excuse the fact that he was speeding, that he was drunk driving, and that he ran from the officer. I think the more common sense thing, rather than going to your house, as defense counsel has argued, is he was trying his best to get away from the officer, trying to go as fast as he could away from the officer to get to his house so he could run in and avoid an arrest for a DUI. He knew he was driving drunk. I think that's the only plausible connection between all the totality of facts. So we ask the court convict him.
Thank you, gentlemen. In making this decision, the court has to look at all of the factors in this case. It's called the totality of all the evidence. The first thing that the court has to determine is there reasonable, articulable suspicion to believe that this gentleman was committing or had committed an offense. And the court will rule that this officer had the gentleman speeding in his radar. The court finds that his stop was legal He was stopping the gentleman for speeding, which is probably amounts to probable cause because it was a radar. So he was stopping the gentleman to enforce the traffic code of Virginia. The next thing that the officer did was smelled alcohol coming and emanating from the car and from the gentleman. And so at that point in time, the officer had reasonable articulable suspicion that this gentleman could be under the influence of alcohol since he was speeding and had gone almost a half a mile before he had stopped. Once he pulled the gentleman out of the car, he administered some field sobriety tests, which the officer is permitted to do. He's properly trained and went through 3 tests. In these tests, the officer is looking to determine how the gentleman speaks, how he acts, how he reacts to stimulus. Can he speak? Does he have slurred speech? Does he have bloodshot eyes? Can he stand and he walk? Can he interact? What he does is appropriate in terms of his attitude, in terms of his demeanor. And once that the officer had done these 3 tests, and what the court looks at is particularly the nystagmus test. It has a validity of about 75% to indicate an individual could be under the influence of alcohol if the tests are there on this nystagmus test. And those clues were there. The walk and turn, the gentleman was attempting to do the walk and turn, and there is clues there that the court looks for in terms of was he able to stand on 1 foot? Was he able to do heel and toe? Did he have to use his arms for balance? And based on what I heard from the officer, the gentleman could not perform that test. In fact, the test was stopped because the gentleman was endangering his own life, afraid he was going to fall. And the 3rd test was the alphabet test, and apparently he passed, or he had no clues on that particular test. The next issue is, did the officer have the probable cause to make the arrest for driving under the influence? Based on the things that I've just spoken about, the smell of alcohol, based upon the 2 tests, the 2 clues, 2 tests that there were multiple clues that he was under the influence, I found at this point in time the officer did have probable cause to take the gentleman down to the magistrate's office and to either seek a blood draw or to do a breath test. The gentleman elected to do, at this particular point, a breath test, and he came back on the certificate of analysis, and it was 0.10, which means, based upon the statutory presumption, the gentleman was under the influence of alcohol at that point in time. The defendant has a right to testify, and he did. He didn't have to testify, but let me say, Mr. Commonwealth and defense counsel, I find that the gentleman's testimony was very flip. He was not very serious about his answers. He was evasive. He felt like everything was just a joke. I find that his credibility in this court is lacking. And so, based upon the totality of all these things, I'm going to find him guilty of the driving under the influence. I'm going to fine him $500. I'm going to give him 90 days in jail with 30 days suspended. I'm going to suspend his driver's license for 1 year. I'm going to require him to go to VASAP, which is an alcohol action program. VASAP is designed to help individuals who may have alcohol problems, and he'll have to take classes, conclude those classes before he can get his driver's license back on a permanent basis. And I am going to require that a interlock be placed on his vehicle. That interlock is going to be there for 1 year with a camera to ensure that if he does get a restricted license through VASAP, that he'll be monitored and he'll not be allowed to drive a vehicle if he's under the influence or if he has alcohol in his breath. So that that interlock, there is a sensor that the individual has to blow in, and there's a code that he has to punch in indicating that it's him wanting to drive the vehicle. And if that sensor comes back that he is either tampered with it or that he's trying to beat the interlock on his vehicle, court will then maybe he may have to face additional charges for the attempting to drive or to tamper with the interlock. And so, sir, your behavior in this court today indicates that you have no respect for the people of this Commonwealth. The court takes driving under the influence very serious. You could have killed yourself, you could kill someone else, and because of that, I've sentenced you to jail time. The other charge is a speeding. The court finds that the officer testified based on the totality of all his evidence and the radar. I find you guilty of $100 in cost. The misdemeanor of looting. I don't find your testimony credible. I don't think you were trying to get home. I don't think you had the problem with the bathroom. I think you were just attempting to elude the police officer. You wanted to go as far as you could, as fast as you could, within reason to get away from him. I'm going to find you guilty. And as a result of that, I'm going to give you 60 days in jail with 30 days suspended. Counsel, he has a right to appeal if he so desires. Mr. Bailiff, we will take him into custody and send him to the regional jail to serve his time.
Thank you, Judge.
Thank you, gentlemen.
Thank you, Your Honor.
Thank you, Judge.
Thank you. Mr. Commonwealth, Mr. Cargill, thank you very much for your services to the Commonwealth today.
Thank you.
Thank you, Your Honor.
I assume at this point in time there will be questions, Mr. Commonwealth.
Yes, Your Honor. If it would please the court, before we begin, if I may, Your Honor, can we give a big round of applause for the court, for the judge, and for all the participants today? Your Honor, and so that the participants know, we've got about 15 minutes or so. There were some questions that were submitted previously. I think several students submitted questions, and we've gone through those, and I'm going to turn the program over to Stephen Davis, my Chief Deputy Commonwealth's Attorney, who will ask the court and the defense counsel and others questions that were previously submitted. If you want to know something that isn't addressed, feel free to grab us afterward or grab one of our assistants. We only have a short period of time, Judge, so okay. I'll try to be brief.
Okay, thank you. Mr. Commonwealth, the audience heard the evidence, and these are typical cases and could have been very well a case that I had heard in court. And these are typical types of cases that we hear on a routine basis in our court every day. And believe it or not, there was something in the script today about these are not my pants. I hear that defense quite frequently from males and females. I don't know how it got there. Those are not my pants, so if it's not my pants, I'm not in possession of the marijuana or the drug. So that's something to do here. The other thing that I hear from defendants quite frequently about how much did you actually have to drink? It's always 2. And so I don't know how they settle on 2, but it's always 2. I only had 2 beers, 2 drinks, and that's generally what we hear. And so that is a common defense that we hear all the time. And so I want to thank you, Mr. Commonwealth, and the defense counsel today for giving me an opportunity to participate. And so, as you can tell, we went quite hurriedly through these to give you an opportunity to hear and see how cases are tried in General District Court. These cases that we hear every day are real-life cases with real-life people with decisions that could end up a defense verdict, or it could end up a conviction, but it's based upon all the evidence. So thank you, Mr. Commonwealth.
Thank you, Judge.
Thank you, Judge. Chuck, I think our first question that was submitted, I'm going to ask for you. If someone deletes something on their cell phone, is it permanently gone, or can it come back, or can they find it on the phone?
Yep.
Is it permanently deleted if someone deletes something?
Well, I'm glad that question was submitted by the students. You know, cell phones are amazing things. It's wonderful that we can communicate with each other by phone. You can access the internet. You can access almost anything just from your hand wherever you are. But the question is, a lot of times there's evidence on phones, either evidence of criminal activity or of a witness to crime. And thus, there's ways that you can get stuff off of phones, and I'm not going to get into it, but law enforcement is quite skilled. They have fancy programs that they can plug phones up to and dump phones and get every text message, every email, every photo, every internet page visited, regardless of whether it's been quote-unquote deleted or not. Once it's there, it's not gone. And not just your phone, but also computers. The state police and Sheriff's Department, and other law enforcement entities, is very skilled in being able to get into phones and computers, and of course with probable cause and with a warrant, but access it and know what you've been looking at and what you've been doing. So no, you can't delete it and expect it to be gone.
Also, a lot of our data on our phones can also be backed up on the cloud or by your carrier, and you can also get a search warrant to search their files as well, right?
Sure. You know, Verizon, you might send 20 text messages, and you might try to delete every one of them off of this and get a new phone, but Verizon knows what you sent, and we can search to get a search warrant and go to Verizon, just singling out one carrier, they're all that way, and know exactly what's been sent.
And Chuck, one quick question for you, one last one for you. If a person, a juvenile, is adjudicated delinquent, does that conviction record stay with you all your life? Does it go away when you turn 18? How does that work?
Well, that's a good question, and those of you at J.I. Burton might have heard me talk about this last week. You know, there's a misconception that everything that's done as a juvenile is sealed and it's private and won't ever come back to haunt you, but it will. It could ruin your life. Let me give you one big example. You know, we heard a speeding ticket case today. When I was 16, I got a speeding ticket. Guess what I had to do? When I took the bar exam, I had to list not only every single place I lived my entire life, but also any time I made any appearance in court at all, including speeding tickets. It came up on the bar exam, right? So you never know when something like that's going to come back to get you. But if you're charged with a felony as a juvenile, you're still going to have your blood drawn, your fingerprints taken, it's going to be put in a database. You can't possess a firearm if you are adjudicated as a felony offense as a juvenile. Plus, criminal background checks are always going to be there. So no, it doesn't go away. It can follow you around the rest of your life. Something as simple as an innocent joke or prank might wind up costing you a job, a good college, a chance to get a great education, somebody invest in your future. It could ruin your life. So you got to be careful what you do, who you hang out with, and don't commit any crimes because it will affect you regardless of your age. Good question.
When I had to apply for the bar, I had to list a parking ticket that I got in college.
Right.
So,
right.
And Your Honor, if I may, this question might be best for you. In your opinion, what is the hardest part of being a judge, and what are the obstacles that judges face?
That's a two-part question, and for those of you who haven't been in court, you're to be commended, and hopefully your life is going to be free of being in juvenile court or general district court or circuit court. One of the hardest things for me as a judge to do is to sit in court and see individuals who've made not one bad decision, but many bad decisions in the series of their life. And consequently, they become folks who have multiple convictions and multiple arrests and multiple jail terms, or either in regional jail or state facilities. And it's very difficult to try to determine how to reach those individuals, that there's got to be a better way in life than spending most of your life in jail or spending most of your life in the court system and having the fines and costs and jail time and a criminal record. A lot of the cases I see are repeat offenders, and consequently you try to determine what is it that is causing this individual to act the way that they're acting, what is causing them not to want to obey the law or comply with the law, and why is it that they haven't learned from their mistakes. That is probably one of the most difficult things that I face every day. And when you see those individuals repeatedly in court, time and time again, it's difficult to ascertain why this person is acting the way they do, why they are getting the offenses that they are. And you know, the thing that keeps coming up in these cases, that most of the individuals that I see on a routine basis generally don't have the skills or the education to work at a job, many cases. Number two, they come from difficult home lives, and they've seen or heard a lot of things in their family setting that kids shouldn't have to see. And it occurs to the court that lots of things that these individuals involved are in is because lots of times they don't know any better. They think that it is the norm that family members treat each other the way they do, or they see things that happening, the drinking or drugs, and consequently they get in this lifestyle. The hardest thing is, how do you change that lifestyle? And as a result, the court only has one option if I find them guilty, and that's generally jail time, prison time, and probation. And that's probably the most difficult thing, the hardest thing that I see from day in and day out, is seeing people that I know that they apparently don't want to change their lives, don't want to change their actions, their behavior, and they're actually become a part of the justice system and the prison system and the jail system, and they know no other life. That's one of the hardest things that I face every day. And the other thing that I see in terms of obstacles that I face every day in helping people, and I'll be very candid and honest with you and the public that's here, there is a drug epidemic in all of Southwest Virginia. I see too much drugs, too many people addicted to drugs. And one of the things that we're seeing right now is a transition from pills to methamphetamine. And consequently, those individuals who are in my court who are getting charged with this are either selling, distributing, and are using all together. And what people tell me, both men and women, is that once they have taken one, and I hold up my finger to one to make sure you understand what I'm saying, most of the individuals that are addicted to methamphetamine, they tell me it only takes one recreational hit of methamphetamine and you're hooked. One, and you're hooked. Most people that I see said, oh, I thought I could stop any time I wanted to. Oh, I just did it once and I thought I'd be all right. Then once became one time, then it becomes 1 year, it becomes 2 years, 3 years, 4 years, and 5 years. And the court, in General District Court, and in many cases the Circuit Court, we don't have the resources and we don't have the ability to help people with true addiction. That's the sad part about it. And I hope, we've talked with Commonwealth about this, and I hope at some point in time there will be an opportunity for this state to find a way to really reach people who have drug addiction and help them reclaim their lives, their family lives, and become hopefully a contributing member of our society and our community. And so that is a huge frustration. I see probably on an average every morning at least 4 or 5 individuals that I arraign, getting them ready for trial, that have addiction to methamphetamine. By and far, that drug is pervasive in this community. By and far, the law enforcement officers are doing all they can do to make arrests and convictions and distribution and use of methamphetamine. But it's a social problem, a legal problem, and a community problem that I find very difficult to get at. I don't know that there's a magical answer or an answer that I can give you today on how to combat or help people with methamphetamine. But my urging to you as a young individual, please don't be around people who are using drugs and methamphetamine, because sometimes it becomes cultural, and before you know it, you're hooked on methamphetamine. I see people every morning that look like death, and they feel like death. And they have no life other than a true addiction. I've seen young ladies give up their children for methamphetamine. I've seen husbands and wives separate and give each other up and their children, their families up because of addiction to methamphetamine. I've seen them steal, lie, cheat, to do anything, to sacrifice themselves ultimately to get methamphetamine. That's how bad it is. So I hope my comments will cause you to think and reflect on your life and what you choose to do in your life. And it's really a choice in your life. But your friends, who your friends are, make a big difference. People tell me every day it's because of the company I keep. It's the people I'm around because I do the things I do. And I hope that you don't fall into that pattern. Thank you, Mr. Conwell.
Thank you very much, Judge. My next question is for Mr. Carrico, Mr. Fleming. What is the most rewarding part of your jobs? Everyone wants to go first.
I think the most rewarding thing I do, let's get this on, and just speaking as a criminal defense attorney, the Commonwealth is not always right. Today's two scenarios were prepared for by the Commonwealth, and I think they were very educational for what you all had to see, but there are times the Commonwealth is not right. Police officers and prosecutors and even defense attorneys, we get skewed by how we see things because the way we're trained. So the most rewarding thing to me is not necessarily a not guilty finding, although that is satisfying. The most satisfying thing to me is when a defendant gets heard in court. I've went into court thinking that there's no way I'm going to win, and win's a bit skewed as well, because sometimes it's about damage control. But when the court gets to see one of my clients express remorse or explain why this activity happened, and the court decides to give a different punishment than what we all thought was going to happen, I tend to find that to be the most rewarding.
Mr. Carrico?
Well, I'll just echo what Judge Phillips said. The reason that I wanted to be a lawyer, I decided that like when I was 11 years old, and it's because I wanted to help people. And when the judge talks about seeing people that he really wants to help, and he's limited in that capacity, I feel the same way. And whether it's as a defense lawyer, I started out as a prosecutor, as the Commonwealth attorney here in Wise County, and so I've seen a lot. I've been practicing law now 20 years, and you were like, what, 22? So we see, and the judge is right, we see a lot of people who just keep staying in the system, and they can't seem to break out of this cycle of drug abuse or alcohol abuse, or just keep making the wrong decisions and being around the wrong people. But the most rewarding part is seeing, is like Brent said, is like, as a defense lawyer, yeah, you may have a case where the Commonwealth's got a pretty strong case against you, but you still want that person to feel like they had their day in court, that they had a fair trial, and they had an opportunity to be heard, and that they were treated fairly by the system. That's rewarding, because even though you may know you're not going to win the case, at least that's a victory in some sense. But I think just helping people is the main thing, making sure that we can help people.
Mr. Commonwealth, can I just make one comment?
Absolutely, Judge.
Additional comment. Not all things go the wrong way for people who have charges. It's very rewarding when I see people in my court and they know that hopefully they get a fair trial, fair hearing, and a fair disposition of their case, that they'll come up to me out in the hallway or out in public, the judge, I listen to what you have to say. I'm telling you, I'm changed. I'm a changed person, and I'm a happier person. That in itself, when you see someone who there has been a success, and there are success stories where a lot of people do change their lives, and they do change their habits and change the people they're with and decide that they're going to do the right thing. That's one of the rewarding things that I think the Commonwealth's Attorney and Defense Counsel and I all share, is that we want to see people do well. We want to see them be productive members of society, be good parents. And, I can tell you some horror stories about what I've seen on methamphetamine. They're just horror stories of what's happened to people and their families. It just destroyed their lives, destroyed their families, destroyed their children. And I just hope somehow we find a way to reach them and to hopefully help them understand there's a different way to do things.
Thank you, Judge. And unfortunately, I know we could probably go all day, but we've about run out of time. So Chuck, final comments, final closing?
Sure. Well, let's hear one more big round of applause for our participants. Thank you. So, Your Honor, I hope that we have provided opportunity for each of you students to see what really goes on in court, see what really cases look like, what defense roles are, what the prosecutor's role is, what the clerk's role is, even court reporter. We got a court reporter here today recording all of this. So, it's pretty cool to get all of that. We leave the four walls of the courthouse and come here to be with you all. I want to encourage you on a couple things. Number one, if this interests you, please come to the courthouse. Please come and watch a case. The court is open to the public, and you can come in and watch what happens on a daily basis. You know, good citizenship begins at an early age. I also want to say how much I really appreciate all the people here that have taken time away from their real jobs to come and be part of this. The sheriff, Chief Lane, the officers, Brent and Joey, the judge, our bailiff. But in particular, when I was in college, Joey Carrico was Commonwealth's attorney. And I did a mock trial at UVA-Wise, wasn't quite sure what I wanted to do with my life. And because of that experience, I said, I want to go to law school. I want to be a prosecutor and help people and turn lives around. So thank you, Joey. But we're here today to do that for you. And maybe one of you is interested because of this in a career in law or law enforcement. Maybe you want to be a judge one day. I encourage you to come and talk to one of us because we want to encourage you. It is a wonderful profession and a chance to change people's lives and try to make a difference each and every day. And the last thing I'll say is this. You're at a critical stage in your life. What you do now will shape your future and the rest of your life. Who you hang around with, what you do for fun. Don't go down the wrong path. At this stage in your life, you're at a junction. You can either go one way or the other. We see, unfortunately, people all the time who've chosen the wrong path. Choices have consequences. Even something innocent to you might be highly offensive or illegal, and ignorance of the law is no defense. You don't want to go down the wrong path. I thank you all for your time, for your attention. I want to encourage you to make the most of every single day because you were put here on this earth for a reason, and you only have a short number of years on the earth, so make them count for the better. Leave this world better than you found it. Thank you all so much. We'll turn it back over, and let's give one big more round of applause for our court.
Thank you, Madam Clerk.
All rise. Court is adjourned.